after the lease is terminated, the landlord can move on to eviction, and the tenant will be served with the rule to vacate or show cause, after which the tenant has 10 days to respond. I would say here, a lot of cases we get, the tenant will have gotten the rule to vacate and will have automatically called the magistrate. And at that point, the magistrate will schedule a hearing. I would say maybe wait, and if you want to seek out legal counsel, if you can seek out legal counsel, you should do it before responding to the rule to vacate. You don't want to miss the 10 days. So if you're at the end of your 10-day period, call and get the hearing scheduled. But if you're early in that period of time, either call legal services or call the bar referral service. So because you may have defenses, you also may want a jury trial, which you have a right to. And if you don't make some of those requests or put those defenses in writing timely, you may forfeit them. So for example, with the jury trial, if you don't request a jury trial in writing 5 business days prior to the date that the hearing is set, then you lose it. So if you call the magistrate court after you get the rule to vacate and the magistrate court says, all right, well, we're going to have this hearing 3 days later, you don't have 5 days. And so you've waived the right to a jury trial at that point. So I would say seek legal counsel before contacting the magistrate court rather than after. And it's always better to file a response in writing. That way you can kind of collect your thoughts, write down why the eviction ought not to go forward. The magistrate will be able to refer to what your arguments are going to be, and you'll be able to refer to what your arguments are going to be at the magistrate's hearing. And then the court's going to schedule a hearing after you respond. If you don't respond, the court's just automatically going to issue the writ of ejectment, and that can be served, and the property can be dispossessed within the time allowed by law, which is really short. If you do have a hearing and the court decides against you, the court will issue the writ of ejectment. That is supposed to be delivered to you and posted at the property, and then at a minimum 24 hours after the posting of the writ of ejectment is when the sheriff's deputy is legally authorized to come back and dispossess the tenants from the home. If you're dealing with elderly or disabled tenants, the statute says that the sheriff ought to exercise discretion in exercising or executing the writ. So you may maybe get a little bit more time if you're elderly or disabled, but it's not a lot. So if you do have a writ of ejectment coming up, moving things into storage might be a reasonable idea at that point. And also, this doesn't really cover it, but there also is the right to an appeal. You would file an appeal if you believe the magistrate made the wrong decision. You would file your appeal at the circuit court. Now, there's a whole process to go through for doing that. So, and I don't think that we really have the time to get into it now, but just know that you do have the right to appeal. If you're being evicted because, let's say, you were accused of breaching the lease by having an unauthorized guest, and you believe that the weight of the evidence, failed to prove that you had the unauthorized guest, you can take that up to the circuit court and let a circuit judge decide that issue on appeal. Just one more thing on the appeals. If the issue is non-payment of rent, there's a statute that requires you to bring the rent current and to keep the rent current while the appeal is ongoing. So that may be an insurmountable barrier in some cases where the issue is non-payment of rent. Because South Carolina law says that even if you do end up bringing the rent current, let's say you bring the rent current 2 months later, the right to evict doesn't go away. So you could find the situation where you bring the rent current and still get evicted, which would be terrible. But just some things to think about. So